Hello everyone, I'm Himanshi Hans. Welcome to part 2 of the video. Today we will be discussing some more constitutional bench judgments delivered in 2024 by Honorable Justice Dr. D.Y. Chandrachud while he was serving as the Chief Justice of India. Let us first discuss the judgment in the case of Association for Democratic Reforms and Another versus Union of India and others. It was a 5-judge bench judgment delivered on February 15, 2024. The majority judgment was delivered by the then Chief Justice Dr. D.Y. Chandrachud for himself and Honorable Justices B.R. Gavai, J.B. Pardiwala and Manoj Misra. Honorable Justice Sanjeev Khanna delivered separate concurring judgment. The petitioners instituted proceedings under Article 32 of the Constitution challenging the constitutional validity of the Electoral bond scheme, which introduced anonymous financial contributions to political parties. The petitioners also challenged the provisions of the Finance Act 2017, which amended the provisions of the Reserve Bank of India Act 1934, the Representation of the People Act 1951, the Income Tax Act 1961, and the Companies Act 2013. There were two major issues involved in this case. First, whether unlimited corporate funding to political parties infringes the principle of free and fair elections and violates Article 14 of the Constitution, and second, whether the non-disclosure of information on voluntary contributions to political parties under the Electoral bond scheme and the amendments to Section 29C of the Representation of People Act, Section 182(3) of the Companies Act, and Section 13A, Clause B of the IT Act are violative of the right to information of citizens under Article 19(1)A of the Constitution. It was held by the Honorable Court that A. The Electoral bond scheme, the proviso to Section 29C(1) of the Representation of the People Act, as amended by Section 137 of the Finance Act 2017, Section 182(3) of the Companies Act, as also amended by the Finance Act, and Section 13A(b) were declared to be violative of Article 19(1)A and unconstitutional. B. The deletion of the proviso to Section 182(1) of the Companies Act permitting unlimited corporate contributions to political parties was declared to be arbitrary and violative of Article 14. Let us come to the next judgment, which is High Court Bar Association Allahabad versus State of Uttar Pradesh and others. This was also a 5-judge bench decision delivered on February 29, 2024. The judgment was delivered by Honorable Justice Abhay S. Oka on behalf of himself and Honorable Justices Dr. D.Y. Chandrachud, J.B. Pardiwala and Manoj Misra. A separate concurring judgment was delivered by Honorable Justice Pankaj Mithal. By order dated 1st December 2023, a bench of 3 honorable judges of the Honorable Supreme Court expressed a view that a decision of the court in the case of Asian Resurfacing of Road Agency Private Limited and another versus Central Bureau of Investigation requires reconsideration by a larger bench. In Asian Resurfacing judgment, the Honorable Supreme Court dealt with the scope of interference by the High Court with an order of framing charge passed by the Special Judge under the provisions of the Prevention of Corruption Act 1988. The issue was whether an order of framing charge was an interlocutory order. The High Court held that an order of framing charge under the Prevention of Corruption Act was interlocutory. There were two major issues involved in this case. First, whether the Honorable Supreme Court, in the exercise of its jurisdiction under Article 142 of the Constitution of India, can order automatic vacation of all interim orders of the High Courts of staying proceedings of civil and criminal cases on the expiry of a certain period. Second, whether it can also direct the High Courts to decide pending cases in which interim orders of stay of proceedings has been granted on a day-to-day basis and within a fixed period. It was held by the court that a direction that all the interim orders of stay of proceedings passed by every High Court automatically expire only by reason of lapse of time cannot be issued in the exercise of the jurisdiction under Article 142 of the Constitution of India. It was also directed that constitutional courts should refrain from fixing a time-bound schedule for the disposal of cases pending before any other courts. Let us move to the next judgment. Mineral Area Development Authority versus Measures Steel Authority of India and others. It was a 9-judge bench decision delivered on July 25, 2024. The judgment was delivered by the then Chief Justice Dr. D.Y. Chandrachud for himself and Honorable Justices Rishikesh Roy, Abhay S. Oka, J.B. Pardiwala, Manoj Mishra, Ujjal Bhuyan, Satish Chandra Sharma and Augustine George Massey. Honorable Justice Nagaratna delivered dissenting opinion. This case deals with the distribution of legislative powers between the Union and the states on the taxation of mineral rights. Entry 50 of List 2 of the 7th Schedule to the Constitution deals with taxes on mineral rights subject to any limitations imposed by Parliament by law relating to mineral development. Regulation of mines and mineral development is enumerated under both the Union list, which is entry 54 of list 1, and the state list, which is entry 23 of list 2 of the 7th schedule. The entrustment of the subject to the state legislatures under entry 23 of list 2 is made subject to the provisions of entry 54 of list 1. Parliament enacted the Mines and Minerals Development and Regulation Act 1957 in exercise of its legislative powers under Article 246 of the Constitution. The subject which the legislation covers is relatable to entry 54 of list 1. The Act is a comprehensive code for the regulation of mines and development of minerals. The Honorable Court held that royalty is not a tax. Royalty is a contractual consideration paid by the mining lessee to the lessor for enjoyment of mineral rights. The liability to pay royalty arises out of the contractual conditions of the mining lease. The payments made to the government cannot be deemed to be a tax merely because the statute provides for their recovery as arrears. The legislative power to tax mineral rights vests with the state legislatures. Parliament does not have legislative competence to tax mineral rights under entry 54 of list 1, it being a general entry. Since the power to tax mineral rights is enumerated in entry 50 of list 2, Parliament cannot use its residuary powers with respect to that subject matter. Let us move to the next judgment. State of UP versus Messrs. Lata Prasad Vaish, which was a 9-judge bench decision delivered on October 23rd. This judgment was delivered by the then Chief Justice Dr. D.Y. Chandrachud for himself and Honorable Justices Rishikesh Roy, Abhay S. Oka, J.B. Pardiwala, Manoj Mishra, Ujjal Bhuyan, Satish Chandra Sharma and Augustine George Massey. Honorable Justice Nagaratna delivered dissenting opinion. Intoxicating liquor falls within the legislative domain of the state legislatures under entry 8 of the state list, which is list 2 of the 7th schedule to the Constitution. The issues in this case pertain to the scope of the power of the state legislatures under entry 8 and the meaning of the phrase intoxicating liquor. The question was whether intoxicating liquor in entry 8 only includes potable alcohol such as alcoholic beverages or also includes alcohol which is used in the production of other products. In Synthetics and Chemicals Limited versus State of UP, a 7-judge bench delineated the scope of the regulatory powers of state legislatures on intoxicating liquor. The correctness of synthetics judgment was referred to a larger bench in this judgment. The issues in this judgment were: first, whether entry 52 of list 1 of the 7th schedule to the Constitution overrides entry 8 of list 2. Second, whether the expression intoxicating liquors in entry 8 of list 2 of the 7th schedule to the Constitution includes alcohol other than potable alcohol. And lastly, whether a notified order under section 18G of the Industries Development and Regulation Act is necessary for Parliament to occupy the field under entry 33 of list 3 of the 7th schedule to the Constitution. It was held by the court that entry 8 of list 2 of the 7th schedule to the Constitution is both an industry-based entry and a product-based entry. It includes the regulation of everything from the raw materials to the consumption of intoxicating liquor. The judgment in synthetics was overruled in the following terms. Item 26 of the first schedule to the Industries Development and Regulation Act 1951 must be read as excluding the industry of intoxicating liquor as interpreted in this judgment. Last, the issue of whether section 18G of the Act covers the field under entry 33 of list 3 did not arise for adjudication in view of the finding that denatured alcohol is covered by entry 8 of list 2. Let us move to the next judgment. Messrs. Bajaj Alliance General Insurance Company Limited versus Ramba Devi and others. This was a 5-judge bench decision delivered on November 6, 2024. The judgment was delivered by Honorable Justice Rishikesh Roy for himself and Honorable Justices Dr. D.Y. Chandrachud, P.S. Narasimha, Pankaj Mithil and Manoj Misra. This judgment decided a reference which doubted the 2017 judgment in Mukund Devangan versus Oriental Insurance Company Limited. The issue in this case was whether under the existing legal framework of the Motor Vehicles Act 1988 and the Central Motor Vehicles Rules 1989, a person holding a license for a light motor vehicle class can drive a transport vehicle without a specific endorsement provided the gross vehicle weight of the vehicle does not exceed 7,500 kgs. The Honorable Court held that a driver holding a license for light motor vehicle class under section 10(2)(d) for vehicles with a gross vehicle weight under 7,500 kg is permitted to operate a transport vehicle without needing additional authorization for the transport vehicle class. For licensing purposes, light motor vehicles and transport vehicles are not entirely separate classes. An overlap exists between the two. The special eligibility requirements will, however, continue to apply for e-carts, e-rickshaws, and vehicles carrying hazardous goods. Secondly, the second part of section 3(1), which emphasizes the necessity of a specific requirement to drive a transport vehicle, does not supersede the definition of light motor vehicle provided in section 221 of the Motor Vehicles Act. Third, the additional eligibility criteria specified in the Motor Vehicle Act and the Motor Vehicle Rules, generally for driving transport vehicles, would apply only to those intending to operate vehicles with gross weight exceeding 7,500 kgs, that is, medium goods vehicle, medium passenger vehicle, heavy goods vehicle, and heavy passenger vehicle. Fourth, the decision in Mukund Devangan versus Oriental Insurance Company Limited was upheld. In the absence of any obtrusive omission, the decision was held to be not per incurium, even if certain provisions of the Motor Vehicle Act and rules were not considered in the said judgment. Let us move to the last judgment in today's video. Central Organization for Railways Electrification versus Measures ESI, SPIC, SMO, MCML, a joint venture company. This was a 5-judge bench decision delivered on November 8, 2024. The majority judgment was delivered by Honorable Justice Dr. D.Y. Chandrachud for himself and Justices J.B. Pardiwala and Manoj Misra. A separate judgment was delivered by Honorable Justice P.S. Narasimha. A separate partially dissenting judgment was delivered by Honorable Justice Rishikesh Roy. The issues in this case were whether an appointment process which allows a party who has an interest in the dispute to unilaterally appoint a sole arbitrator or curate a panel of arbitrators and mandate that the other parties select their arbitrator from the panel is valid in law. Second, whether the principle of equal treatment of parties applies at the stage of the appointment of arbitrators. And last, whether an appointment process in a public-private contract which allows a government entity to unilaterally appoint a sole arbitrator or majority of the arbitrators of the arbitral tribunal is violative of Article 14 of the Constitution. It was held that the principle of equal treatment of parties applies at all stages of arbitration proceedings, including the stage of appointment of arbitrators. Second, the Arbitration Act does not prohibit public sector undertakings from impaneling potential arbitrators. However, an arbitration clause cannot mandate the other party to select its arbitrators from the panel curated by the PSUs. A clause that allows one party to unilaterally appoint a sole arbitrator gives rise to justifiable doubts as to the independence and impartiality of the arbitrator. Further, such a unilateral clause is exclusive and hinders equal participation of the other party in the appointment process of arbitrators. Unilateral appointment clauses in public-private contracts was held to be violative of Article 14 of the Constitution. With this, we come to the end of this video. I hope you found the discussion to be fruitful. Thank you so much for watching. See you next time. Bye-bye.